about. Did anyone by chance read the materials on the case that I presented? Who actually read it, like for real? Okay, that's great.
They were threatened with various courts.
There was a lot of reading, so apologies if you didn't like it. Did you read the rebuttal speech? Okay, that was only 10 minutes. I only got 10 minutes. I co-tried the case with a great lawyer from Texas. His name is Jason Itkin. Jason is just a phenomenal lawyer, and I split up the duties, and I did the opening, the closing, I did the rebuttal. So I get all of that pent up energy and anger out like in one fell swoop, as in the defense lawyer said, Mr. Kline's gonna get up, he gets the last word, Mr. Kline's gonna try to get you angry, try to get you riled up. And what did I say? I said, Mr. Kline is here because you should be angry and you should be riled up based on the evidence that you saw. And my pitch in the case was largely to get the jury to award punitive damages. And the version that you saw is, as I like to call it, 3.0 in a series of cases that have been tried over the past 12 months. For better or worse, I've spent, I counted it, 12 of the past 52 weeks from trial to trial in a courtroom on trial in my 46th year of doing this. So I tell you that story, not for bragging rights, but to say you can actually do something for a long time and actually love what you do. And being a lawyer is a great thing. And you got to find the niche that you like and the kind of law that you like to practice. And then hopefully do it with the kind of love and passion that I hope that I've got it with. Because I had none the less of any passion than I had 46 years later standing in the courtroom, presenting a witness and giving a closing speech. So that's the philosophical part of this little exercise. And there's a lot packed in that trial. And what I presented in my materials, and I want to divert back to your readings and hopefully crossbreed and hopefully cover the material that we should be covering today. And interactivity is more than welcome. Don't let me talk at you, talk with me. I want to cover through hopefully this trial and the readings the major elements of damage, because this case had a lot in it about damages. And instead of giving you the opening statement, I gave you my presentation of the witness himself, the plaintiff in the case. Plaintiff was my responsibility, and that was a carefully crafted presentation with specificity. My law partner, Shane Spector, who has taught this class at this law school and other law schools, is fond of saying that a direct examination is oftentimes much more difficult than a cross-examination. Intuitively, we think, oh, a cross-examination is difficult. I got to challenge somebody's hostile, but it's really not. You get to ask leading questions, you get to direct the narrative, you get to control the witness if you're good at it, and so, and you can get the result that you achieve. I never have, like, don't do a sweaty palm, but I never have the proverbial sweaty palms when I'm getting ready to cross-examine a witness. I do when I'm putting my witness on the stand, and in particular when I'm putting my plaintiff on the stand. And so what I wanted you to see in the case was the actual presentation of damages, and what I did, or what we did as a team, to craft the damages portion of the case to try to get the story that we wanted it to tell. Because you saw, as in every case, part of the story. You didn't see the whole story. So let's kind of unpack it and unwind it and hopefully get a good, robust talk and an understanding of punitive damages as well as compensatory damages. So let's kind of start with basics as to what you might have seen and you didn't see in that case. Okay, you've read about damages. You read about the various elements of compensatory damages, and I've already learned that you've heard about actuaries. Yes, I saw many actuary in my life in plaintiff's cases, and you've heard about other economic calculations to get at some of the damages. So let's break up damages. I know that your book says there's nominal damages. Okay, well, we're not interested in nominal damages. So as a general rule, I don't want to talk about nominal damages as the plaintiff's lawyer. I'm not interested in anchoring the case on a $5,000 or $10,000 funeral bill. Why would I ever want to put in the funeral bill? By the way, when I was more your age than my age, and just had a law license and had my first case, I put in the funeral bill. But I didn't know better. You have to learn how to do these things, but why do that? There's a concept called anchoring where you want to get the jury to latch on to an idea or a concept. In most states, I think 46 states, I may have the exact number wrong, but I think it's 46 states, you are actually allowed to suggest an amount to the jury, as in, and when you go back there, into the jury room, and you're selected as a foreperson, I can't do that. And you're deliberating, you're going to have to decide how much is fair. And in this case, this is a multi-billion-dollar corporation that has sold billions and billions and billions of dollars worth of this poison, this, as I like to call it, cocktail of poison. You get the gist on the Roundup case. How many of you use Roundup? Lots of hands always go up, sure. My personal views don't, but if you want to keep using it, yes, after your keeper. But the important thing that you need to focus on is whether you can or you can't suggest a number. I could, in most jurisdictions, say, and in order to properly punish this company, you need to award $10 billion. You can't do that in Pennsylvania. Did you know that? Yeah. You can't do that in Pennsylvania. You can't do it in New Jersey. You can do it in almost every other state. So that's why you didn't see any suggestion of any amount of money. In every jurisdiction, in every state on compensatory damages, you can award, you can ask for not only the nominal damages, but the other damages. And I divide damages in my head into two parts. Economic, it's sort of laid out this way in your textbook, but not really. But I divide it as, I actually wrote the material. I divide it into economic damages and non-economic damages. And what are the elements, the general elements of economic damages? Help me. I want to see that everybody's still awake. Help me. Economic damages. There are, come on, anyone will do. Okay.
Medical bills, for example.
Medical bills are a good example. In some cases, they could be an anchor to the case. And in Pennsylvania, for example, in some kinds of cases, you can't collect the medical bills. For example, in a medical malpractice case, it's a statute where you can't collect them, but you can use them to show the jury that the medical bills were large. For example, would you want to show the jury that the medical bills were $5,000? No. Would you like to show the bills even if they weren't collectible to you, and you have a case on this point? I know you read a case on the collateral source rule. You know the collateral source rule?
We talked about it in my big thing. Yeah.
Okay, good. And you can in most jurisdictions collect those damages, right? But you didn't pay all those damages because they were paid for by the insurance company. But what the jury doesn't know is there's a lien against them, and they could be for part of them or all of them. And courts have generally said, oh, that's the medical bill, that's the medical bill, and we all know the medical bill is more than the amount that's actually paid by an insurer. You get that point? Yes, no, say yes if you got that point. Okay. So those are damages, medical bills. What else? Yes, ma'am? Loss of income. In a death case, that would be actually called a loss of earning capacity. And in some cases, for a living person, it would be. So someone's injured, working on a job, loses a couple of fingers, can't work, can't be a plumber, gets files a lawsuit, proceeds with the lawsuit, gets the case in front of the jury, and then you might put in the past lost earnings. Those are lost earnings. And then future lost earning word capacity. Did I hear the mumble? Yeah, lost earning capacity. That's right. That's different. And there are different states have different rules. For example, in Pennsylvania, we're very generous. We will have an economist project the loss of earning capacity of literally a baby who died, or a child who's severely injured and won't be able to work his life or her life. You can't do that in New York, but just by way of comparison. Different laws, different statutes, different common law development. You have to know where you are and what your jurisdiction actually says about it by statute and by law. But there are kind of different rules that apply. But as a general rule, you can seek loss of earning capacity. So there's loss of earnings, loss of earning capacity in the future, medical bills past, medical bills future. You use an expert to do that. What you do in a catastrophic injury case is you bring in a life care planner, someone who is trained to evaluate someone's capacity and their needs in the future, then project them out. Did you know in Pennsylvania we don't put a lump sum on that amount of money? You know what we do? We give the jury literally somewhere between, in a case of a child, 15 to 80 lines, depending on what you think the life expectancy is. And every year the jury has to fill in a number. So sometimes the jury slip on a damages case involving an injured person with future medical bills can have lines going out to 2080, 2090. Isn't that interesting? That's the medical malpractice statute actually here in Pennsylvania. Are there other economic damages that you can think of? Yes.
Is it cost of childcare if someone's with primary caretaker?
Could be. Tricky. Could be. It actually could be, but not usually. Would you consider that an economic damage or a non-economic damage?
Potentially, maybe a point civil
Watch me be a lawyer. Would you consider that an economic or a non-economic damage?
Well,
Can it be quantified? Is that a quantified number or a non-quantified number?
Probably a non-qualified.
So what would it make it? Yes. Pretty good cross-examiner. As a non-economic damage, sir, yes, we agree. Or as I like to say when I cross-examine a witness, let's see what we can agree on. I know we're not going to agree on a lot, but I literally say to witnesses, let's see what we can agree on. Okay, that's one non-economic damage. Let's see what else. Disfigurement? I heard. Yes.
So physical pain and suffering.
Are you going to wear that all day, by the way?
Yeah. Physical pain and suffering,
All right. Pain and suffering, past and future. Did you know in a death case, at least in Pennsylvania, pain and suffering is in the statute, is in the survival statute, but actually the other elements that we're talking about, like disfigurement, are not. It's kind of a crazy quirk of our law. Yes, go ahead. Disfigurement, pain and suffering. Does that include just physical? I'm going to give you a hint on that.
No.
Mental anguish, let's call it mental anguish. Yes. That's something a little bit different. And let's talk about that for a minute. Because all of these elements are different. And and you get it, by the way. And what I like to tell a jury when I give a closing statement is that there are various elements. And as I like to say, they are terms of art. They actually are compensable. Like you think disfigurement or loss of life's pleasures, you, if you're a juror in this case, you've been sitting here for 4 lousy weeks listening to this stuff. And those, the concept of loss of life's pleasures is a compensable item of damages. So you need to think about what have been those losses and what are those losses going forward. And that would, in a case of someone who, for example, has sustained brain injury and can't process thoughts anymore, then they have to be, that has to be accounted for. What's the value of not going to, what's the value of going to your daughter's wedding in a wheelchair and not able to process what's going on around you? What's the value of that? That's a non-economic damage. Because I can't have someone quantify it as a general rule. There are kind of goofy ways some people do it, but I don't buy it. At least our Pennsylvania courts don't buy it. So you have loss of life pleasures. They're called by a little bit different words in different jurisdictions. Loss of life pleasures, pain and suffering, mental anguish, disfigurement. And then there's another one, at least in Pennsylvania, how we quantify it, and it's different names in different jurisdictions, so it's called something a little bit different in the textbook, and that is embarrassment and humiliation. Those are 2 separate terms. I'm sorry, in Pennsylvania they're lumped together. We recently tried one of the roundup cases where the judge would not allow embarrassment and humiliation to go to the jury. He would not submit that element of damages. The judge saying, I didn't hear anyone say that. I didn't hear any evidence of it. And I argued that it could be inferred. And I kind of shrugged my shoulders and we moved on. But if you were actually trial counsel in a case representing a plaintiff, I think that would be fun to do someday. I could use your law degree. I think it is. And who would rather defend a big corporation, by the way? That's fine too. But what you find yourself arguing in these cases is a way to get at the elements of damages. So you want to talk about loss of life's pleasures. You see loss of life's pleasures in my examination of Mr. Nelson. Did you? Did you see embarrassment, humiliation? We're going to talk about that. Did you see pain and suffering? Did you see mental anguish? Now what I'm having you do is look at that examination of that witness that you so kindly took the time to read, and you're looking at it through the prism of the way a jury would have to look at it as the jury gets the law explained by the judge. Members of the jury, there are various elements of damages in this case. There are economic damages and non-economic damages. But here's the interesting little ditty here. Did you see anything about loss of wages in my examination of Mr. Nelson? No. Did you even see me talk about what his job was? Does that bother you? Did you just think about it? You think I wonder what the guy did? I mean, you knew he was a landscaper, but okay. And then, but I didn't ask his current job. I didn't ask his current job for a reason, by the way. I don't want to talk about it. I think they cross-examined on it if they wanted to, which they didn't. But I didn't ask him about it because I don't want to talk about the guy's job and his work. I want to talk about his fear of cancer and his fear of his cancer recurring. That was my strategy. So all of these elements of damages are built, and the evidence that you put in the case, plaintiff or defendant, the evidence has to be structured in a way that it fits within the framework of the damages which are being claimed. One of the great mistakes that's made by lawyers, and not just young lawyers, and especially plaintiff's lawyers, is that they don't recognize sometimes that there's an old saying, if you don't ask for it, someone can't give it to you, can they? You have to make the ask. And so you have to actually know why you're in court. If you're bringing a civil action for damages, what are you seeking? Help me. What are you seeking? Damages. And so you have to start with yes. That's the only thing a jury can give you. So you can talk all you want about liability, which includes, in this case, it includes a pattern of 50 years of what we believe is misconduct, fraudulent studies, payments to, in one case, to a lawyer's fee for a person who had been convicted of a crime who ran a laboratory, failing to test the product, paying millions and millions of dollars to various people to try to promote the safety of a product which clearly is unsafe. And that's all part of proving the negligence claim and proving the product liability claim. In this case, we had a claim for negligence. Let me show you the verdict. We had a claim for product liability in Pennsylvania. It comes in two parts, and we didn't do any products or much product liability yet. So I won't go there. And there's a claim for failure to warn, which is kind of a hybrid. But if you fail to warn about something, that is, generally speaking, a negligence concept, because it's a negligent failure to warn. And then if the conduct rises to a level of, what level does that have to rise to? You get a judge in the first instance as the gatekeeper to allow a jury to consider punitive damages, and then a jury to consider punitive damages. What level of misconduct does it need to rise to? Because you're going to have to get there with me to understand the case that I'm presenting to you today. What's the level? Level of misconduct. It's not ordinary negligence. What's ordinary negligence? Real quick, refresher course. What's ordinary negligence? Failure to act. Like deep breath. Yeah,
Imagine how I'm feeling.
Failure to act, right, failure to act reasonably. It's that simple. If you don't exercise reasonable care, I mean, what rises to the level of exemplary damages? The conduct which is beyond negligence. Yeah, go ahead. Outrageous. That would be the definition in Pennsylvania. Can you put some meat on the bones here for me? Did you cover this yet? A little bit.
A tiny bit.
Okay.
Yeah, and it's in the reading.
Okay, and this is really important. Like, this is before you get to State Farm and ratios and what would be considered it. Like, let's talk skeleton before we talk Halloween costumes. Like, let's get to the skeleton. Yes. That would be the legal standard by which you need to prove it in some states. But that would not be the element, that would not be the degree of conduct is what I'm getting at, yes?
Reckless disregard for others.
Reckless disregard for others. Anyone want to add to that because it's an alternative standard? Yeah, generally speaking. Some places, yes, but most places, no. Gross negligence is this amorphous concept of it has to be somewhat worse than ordinary negligence, whatever that means. And for example, by the way, there's a statute in Pennsylvania that EMTs, by way of example, are held to an emergency room, emergency responders are held to a standard of gross negligence in order to be held liable. Did you know that? Not ordinary negligence. Gross negligence. But that's not what I'm talking about. I'm talking about reckless disregard of a known risk. Reckless disregard of another's safety is generally the standard. Wanton, willful, or reckless disregard is mostly what the standard is written. Textbook may have some different languages that came from different jurisdictions There's a general proposition, that's what you're talking about.
The
And-
textbook talks about shocking the conscience. Do you guys remember reading that
Yes,
phrase a
thank
bunch
you.
of times?
Yep, thank you. Shocking the conscience. If you shock the conscience, then that is also it. You need to prove reckless, the standard that most of the time is actually tried in a courtroom is reckless disregard of the safety of another person. That's not a very high standard, by the way. And there needs to be a conscious element to it. You need to know what you're doing and then go and do it anyway. So it's not negligence, which can be passive in nature. You can fail to do something. You can do something by omission. Got it? Okay. So in this case, let's focus on Mr. Mellison for a moment. Okay. What did the plaintiff's lawyer do in that case? Somewhat creatively. And what did he spend a lot of time talking about in the case that he might not have much to have done with you, Mr. Mellison? Who did the plaintiff's lawyer want to talk about more than Mr. Mellison? Yes. Stanley in particular. In particular, his daughters. They can come after. But in particular, his mom. Did the plaintiff's lawyer make the case about his mom? Arguably. The plaintiff's lawyer, at the end of the day, this is an appellate issue that's been raised by the defendants. He said, remember the mom's name? Mary Jean. Mary Jean. And do you remember when the plaintiff's lawyer said, when you evaluate this case, I want you to, and the words are very carefully chosen. I didn't say money, but that plaintiff's lawyer didn't say money. He said, evaluate the compensatory damages in Mary Jean values. Mary Jean values. Now, I think that's pretty clever, if I might say so myself. And by the way, I thought of it, that guy thought of it on the spot. And I want you to award punitive damages based upon Monsanto values. Again, carefully chosen words, because that plaintiff's lawyer knows that that speech is going to be reviewed by an appellate court. So words matter in the presentation of evidence. I know this isn't a trial ad course, I know this isn't an evidence course, but all of these things are combined. I want to tell you something as 1L. Some of you might have heard me say this, but it's actually true. This is in the philosophical moment. Everything that you do has to have a purpose. And so you need to purposefully think about what you're doing and what you're saying, and you have to be thinking ahead about that as you move through the course of presentation of any evidence in any case. So, back to this. What do you think of the fact that his mom had 16 kids in 20 years? Well, the jury thought that was like the best story. Having heard science and epidemiology and a lot of rancor and a lot of fighting, to hear that nice story. And I decided that if there were a way to humanize William Mellison, and by the way, talk about his loss of life's pleasures with who gave him his daughters, who got his daughters, or who purchased his daughters, thank you. To get to the daughters, you need to get to the mother. And what did I make the whole case about? Think about it. Mother, Then what happened? Then what happened there, by the way? 15 to 16 kids. What do you learn if you're the 15 to 16 kids, the last of 9 boys? You learn about values. You learn about living together. You learn about community. You learn about helping each other. And what was I asking the jury to do at the end of the day, when you think about it in non-legal terms? I was asking the jury to help him, isn't it? What do you think? So, why talk a lot about his landscaping? I needed to hit some basic elements, didn't I? You know, he used a lot around it. In current course, he used a blank load around it. And apparently now you can say whatever you want. I guess that's our America, if you're an American. That's a political comment. I don't want to go any further. I promise. So all of these things are relevant. That's the key point in damages. I wasn't talking about Mary Jean to talk about Mary Jean. I was talking about it, and by the way, and the judge was a little bit impatient. I'm here, I'm looking at the witness, and I'm also looking at the judge. And I know that he is, I can see that he has that, when is the mom stuff gonna end? Like I can see that happening in front of me. But, and at one point, I think he interrupted me. And what I said to him was, kind of tersely, but nicely. I said, I need this to prove the elements of my case. And the elements of my case that I wanted to prove were this was a nice man who suffered a very bad injury and who needed, you needed to understand him through his life's experience. And so you have an advanced lesson here. This isn't a primary lesson that I gave you. It's an advanced lesson in damages, in how you actually present and how you deal with damages. But I didn't only latch on to mom, did I? Then I latched on to, this is what I like to say. I latched on to his wife, who happened to be his high school sweetheart, coincidentally. I mean, it's a storybook. It's a storybook. And then, as I said to him, and then you had 3 sons. That's when I knew I was going to get a little leeway, and I didn't think I was going to get yelled at, although there was a chance, but I was going to do it anyway. I could have said, and you have 3 daughters, but I wanted to incriminate myself to be really, I admit it. It's true. And then he said, no, I have 3 daughters. So what is the arc of the man's life? This man who's suffering from cancer. I mean, this is truly, by the way, a month ago I wouldn't have had this to bring to you. That's why it's fun to be a trial lawyer and try the next case. Last year, the class just heard this other man's saga, which I'm going to tell you about in a minute. But what did I build the story on? I built the story on the women in his life. And I was trying the case to, and what happened to his dad? What happened to his dad? Yeah, what the jury didn't hear is his dad was thrown out of the house for being a very bad guy. And I questioned what would happen if they knew the real story. And all I had to do was to tell you if they knew the real story, they didn't know the real story. It was really ugly, really ugly. But I decided that I was going to tell the story without telling the story. His dad was thrown out of the house. And the key point is that he left. And so there are all of these life lessons that are wrapped up in this one kind of average Billy story. He's a landscaper. None of the 16 kids went to college, and none of them got in trouble. What a legacy for a mom, by the way. And I wanted the jury, when they went back to think about the damages in this case, who do you think I wanted them thinking about? Mom. Now I want you to focus on his damages for a moment. How much did the jury award? that? Maybe you didn't get that back. I'm gonna get there with you.
You asked
So-
me not to post.
That's right, yeah. So, let's take a look at what the jury did. I just hit the button.
Yep, it is viewed, but it should come up right here. There you go. And then you can use the mouse to scroll through the pages. Here, just use the mouse that's down by the keyboard, Tom. Keyboard's on the drawer, and there's a mouse there, and you can scroll through with that.
Got it. Okay, so, were you interested in how much the jury awarded?
Yes.
Like, how much did the jury give Mr. Kline is gonna come in and brag about this case with me? Okay, so, here's what happened. The jury was asked, was Monsanto negligent? That's for another day, because we're on damages. And they were asked these questions. They awarded him $3 million in compensatory damages. Here were his damages. He has a cancer called hairy cell leukemia. Hairy cell leukemia is a variant of non-Hodgkin's lymphoma. Non-Hodgkin's lymphoma is one of the most common cancers in the world, and certainly in America. We claim that it is largely environmentally caused, and particularly caused by this product called Roundup, which is, by our definition, a cocktail of poisons. A poison that kills the weeds, poison that spreads it over the weeds, and then a cocktail of other things that are byproducts of the manufacturing process, like a garnishment of arsenic, formaldehyde, and ethylene oxide. I kid you not. And so that's our claim. And Mr. Ellison had hairy cell leukemia, which is a variant of this kind of cancer. And he had 5 sessions, not 5 rounds, 5 sessions of chemotherapy. By all accounts, is in remission. Hasn't recurred in the last 5 years. And has kind of a 50-50 chance, if he gets to the 10-year mark, of survival, which he's not at yet. Those are kind of roughly the statistics. The best evidence in the case that we could get out of his treating doctor was that he's, quote, not out of the woods. And their argument on the other side of this case in terms of damages was fine, he's working, he's walking, take a look at him, he's still drinking beer. That's kind of a joke, but kind of not a joke. He's doing fine. Now, what we didn't talk about, and I don't know all the damages that we've talked about so far, and what do you think of $3 million? What were you at when you were thinking in your mind? What were you thinking you might award? Did you give it any thought while you were looking at the case? You didn't know. Was it a $100,000 case? Was it a $500,000 case? Was it a $20 million case? We've now tried 3 of these cases. One for an 83-year-old man who is very ill. He was very frail. His name is Ernie Garanci. He had a nice life story. Came to America from Italy. Married to the same woman for 60-some years. Ran old original Ernie's pizzeria across from Northeast High School. And these people here, these village folks here, and you probably know where it is. Original Ernie's. And but Ernie was an older man. The jury awarded $50 million in compensatory damages. And the second case involved a younger man who was 40-some years old who had cancer that was in remission. The jury awarded $25 million. And so if you set your standards very high and your expectations very high as a plaintiff's lawyer, then you are bound not to meet them every time. But by any account, I think this is a interesting here, you don't see a claim on the verdict slip for someone else who might be a plaintiff. And I don't recall seeing it in the materials, but was loss of consortium covered in the materials? I just might have missed it. Very briefly. So there are two kinds of claims. And so I would say write it down, you have to write it down, put it in your head. There are direct claims and there are derivative claims. You can have a derivative claim off a main claim, and that is what a consortium claim is. So his wife, we pled in our pleadings a consortium claim, a lack of consortium claim, but we did not seek to prove it in front of the jury. And could have, but we were not interested in strategically in diluting it and having the wife testify and taking the emphasis off of his claim. So that's how we handled it, and that's what we decided to do. I'm at 10:16 is my own time. Oh, I gotta really hustle. Yeah, I misjudgment. I hope I covered some territory. So, punitive damages. So, you saw the rebuttal speech, and I want to cover the damages briefly. How much is the award? You know? Oh, it's on there?
Well, I thought we could go.
Okay. Always pretty cool to look at it. So here's what happened, and this goes to some of your readings, like in real life. I believe it or not, every day I get up and I practice law every day. Every day of my law practice is a day in first year torts, civil procedure, I kid you not, torts, civil procedure, contracts, because all settlements involve a contract. And I'll push you ahead a year or two, depending on when you take it in evidence. Every day, I have to do that. Actually, with all these cases, like every day, I see not every concept every day, but every concept every day. So, the jury awarded $75 million, and I know you had some readings. I want to cover two things real quick and not trespass more than a minute or two over. A couple of things here. One is the ratio of the punitive damages, because you know the State Farm case, and I know you read the State Farm case, but I want you to keep in mind something about the State Farm case. The State Farm opinion is misread by, in my view, nearly everyone, because it basically says that there is a presumption that a single-digit ratio between compensatory and punitive damages is constitutionally appropriate. But it doesn't. But it also says that it also does not exclude the possibility that in some cases a ratio that is not single digits may be appropriate. That's a really important concept that's embedded in the State Farm case. Got it? Really important. Like, you can actually have an award that's more than a single digit ratio. What I find in actuality, in real practice, is that 2-1, judges have a knee-jerk reaction to cutting a punitive damage award to the kind of upper limits 9 times the compensatory damages. It happens like night follows day. I had an $8 billion with a B jury verdict about 5 years ago involving a antipsychotic drug known as Risperdal, which was off-label marketed to children. And jury awarded $8 billion off of a with a $800,000 compensatory award. 800,000 compensatory, 8 billion to be in punitive damages. Yes, it's the largest jury verdict in Pennsylvania history. Somebody else said that. And in the prior roundup case, the second of the two, we got a $2.2 billion jury verdict, $2 billion of it representing punitive damages. And there's a reason why, because all of the stakes in these cases are billions of dollars involving multi-billion-dollar corporations. So you got to look at State Farm through the appropriate lens, in my view, which is that, yes, punishment is tied to the conduct in the state. And that case follows, and it's mentioned in your case book, it's mentioned in State Farm. It follows a case called BMW versus Gore, Gore versus BMW. And that was a paint job went bad. It cost hundreds of dollars to repair the paint job, and the jury awarded millions of dollars. And the Supreme Court once again said the same thing about ratio. But here, you see a ratio problem? Sure. I mean, that ratio problem is going to be addressed. The other two roundup cases, we have 25 million against 150 in punitive damages. Ratio works. We have a second case of 50 million in compensatory, and 50 million in compensatory and 2 billion in punitives, which was reduced to 400 million. And now we have this case. So lawyers actually think about all of these issues like these are real issues, real life issues, all of the time, at least in my life and in my law practice. And I thought exposing you to it in a real life setting, with a real case, with real damages and a real person would be helpful. The other thing I might add in terms of lawyering, I personally spend, in addition to a team of lawyers preparing the client for many hours, I think I spend the better part of a week, probably 30 to 40 hours, knowing my client, learning about him, working with him, learning every last detail, so that I can try to present him in the best light, so that the jury can award him the most damages based upon the evidence that we're allowed to present. And as you saw, the cross-examination was limited. So that's my story. I think I have not overstayed my welcome. Happy Halloween.